Welcome to The Explainer. Today, we're digging into a law that impacts literally thousands of renters and landlords across the cities of Punjab, the Punjab Rent Act of 1995. So, if you're a landlord renting out your place or a tenant searching for a new home in Punjab, this act is basically the official rulebook for you. It was really designed to bring some much-needed clarity and fairness to the whole rental scene, spelling out the rights and duties for everyone involved. In this explainer, we're going to walk through the 5 key parts of the Act. First, what is this thing? Then, why written agreements are now a huge deal. We'll also look at how rent and other charges are handled, who's responsible for what repairs, and of course, the big one, the official rules for eviction. Okay, let's dive right in. First things first, what exactly is this law all about, and who does it actually apply to? The mission of the Act is, well, pretty simple, to regulate the entire rental process from start to finish. You can think of it as swapping out all the old guesswork and verbal agreements for one standard, legally binding framework that everybody has to follow. So the Act has a pretty wide net covering most private properties in cities, but the exemptions are really key here. For example, by giving newly built properties a pass for a few years, the law actually tries to encourage new housing development, without putting immediate regulatory brakes on it. The law is also super specific about what it calls premises, and the definition is broad. It's not just the 4 walls you live in. It also covers any gardens, grounds, or other little buildings that come with the rental, the whole package. And what about a landlord? Well, it's not always just the owner of the building. The Act keeps it simple. A landlord is anyone who has the legal right to collect the rent. So that could be the owner, sure, but it could also be a trustee or even a property manager. And on the flip side, a tenant is just as straightforward. It's the person who's on the hook to pay that rent. It's a simple definition that really clarifies who's who in this legal relationship. All right, let's get to what is probably the biggest, most fundamental change this act brought to the table, the written agreement. If you take away just one thing today, let it be this. Under Section 4 of this Act, the days of handshake deals are completely over. Every single tenancy, no exceptions, must be based on a written agreement. This is the bedrock of the entire system now. And making it all official is a really simple 2-step process. First, the landlord and tenant create and sign the written agreement. Second, they have to register it with the local rent authority. That registration step is what makes it a real, legally recognized document. So, now that we've got a formal agreement, let's talk money. The Act doesn't just manage the relationship, it also creates a clear structure for what a tenant has to pay. What a tenant pays is actually broken down into these really clear parts. So you have the base rent, but on top of that, there's a 10% maintenance charge, a fair share of the property tax, and of course, any utilities they use. This whole system is designed to stop landlords from just tacking on random, unexpected charges. The Act also lays out exactly what happens if payments are late. If a tenant doesn't pay on time, they're on the hook for simple interest on the overdue amount at a rate of 15% per year. It's a clear, predictable penalty, so there are no surprises. But hey, this relationship isn't just about money. The Act also creates a very clear division of labor when it comes to keeping the property in good shape. It's a real two-way street. The responsibilities are split right down the middle. Generally speaking, the landlord handles the big stuff, the major structural things, like the core plumbing and electrical systems. The tenant, on the other hand, is responsible for the day-to-day upkeep and has to fix any damage that they've caused themselves. So, what if the roof is leaking and the landlord is nowhere to be found? Does the tenant just have to, live with it? Nope. The Act gives a very clear path forward. Section 17 is a really powerful tool for tenants. The process is crystal clear. First, you give your landlord written notice. If nothing happens after 3 months, you can get permission from the rent authority to do the repairs yourself. And here's the best part, you can deduct the cost directly from your rent. That gives tenants some serious leverage to make sure their home is safe and sound. And finally, we get to the most serious issue in any rental relationship: eviction. The Act is incredibly careful about balancing a landlord's right to their property with a tenant's need for stable housing. The law starting point is to protect the tenant. A landlord can't just evict someone because they feel like it. An eviction can only happen if there's a specific, legally recognized reason, one that's spelled out right there in the Act itself. And reasons for eviction are very specific. Things like not paying rent for 3 months straight, using the property for something it wasn't meant for, or causing major damage. A landlord can also get their property back if they genuinely need it for themselves. The whole idea is to move these disputes into a formal, evidence-based process. And to stop landlords from abusing that "I need it for myself" clause, the Act adds this extra layer of protection. If a landlord evicts a tenant claiming they need to move in, they are blocked from renting that property to a new tenant for at least 3 years. It's a great way to make sure the reason for eviction was legit. So to wrap it all up, the Punjab Rent Act of 1995 is all about formalization. It forces everything out into the open with written agreements, clearly defined duties, and specific rules for eviction. The goal is to make renting in Punjab cities way more transparent and predictable for everybody involved. And that leaves us with a final thought to chew on. With such a detailed set of rules on paper, does the Act really strike the perfect balance? Does it truly protect tenants while also respecting the rights of landlords? That's a question worth thinking about.